Corrections and Institutions Committee. It is Thursday, April 10th. We're continuing our work on going through some preliminary introduction of bills in our committee. We're now on H379, which deals with creating a procedure for folks who are incarcerated to look again at their sentencing and possibly reduce their sentence. We have not heard from the committee sponsors at this point. We've been having some trouble with scheduling, so we have Ben, Mel Bogroski, our legal counsel, that will give us a really broad overview of what the bill does, and then we will decide as a committee if we'd like to continue, if we'd like to do more work. So Ben, welcome, and if you could identify yourself.
Thank you, Madam Chair. My name is Ben Novogrodsky from the Office of Legislative Counsel, back again.
Good to see you. I haven't seen you in a while.
No, I've been MIA.
Yep.
So before the committee today is H379, entitled An Act Relating to Second Look Sentencing. And essentially, the title itself is really indicative of the bill, because it proposes to create a procedure under which an incarcerated person serving a term of imprisonment of at least 15 years who has served at least that amount may petition the sentencing court for a reduction of the person's term of imprisonment for various reasons, mostly including medical conditions that may require some sort of reduction in sentence. So that's really the general concept that we're working with. And then I can get into the details of the bill itself unless there are any preliminary questions.
I think so.
All right, seeing none. Section 1 is a findings and intent portion of the bill. So this cites various statistics. The first one is from DOC itself, that 20% of the state's incarcerated population of 851 sentence offenders are serving life sentences, 151 persons with the possibility of parole, and 14 persons serving life without the possibility of parole, or a quote unquote virtual life sentence of 50 years or more. The department's data shows that Vermont's 20% figure exceeds the national average, in which approximately 1 in 7 incarcerated persons are serving a life sentence. The Sentencing Project's research demonstrates that Vermont's offenders subject to a life sentence increased by 11% in the 4 years between 2020 and 2024. And according to the U.S. Census Bureau and other sources, the per capita cost of incarceration in Vermont is $134,218. According to academic research, there are 52 persons with some form of a life sentence who are 55 years of age or older, carrying an annual cost of $6,979,336, excluding care costs relating to common chronic health conditions experienced by this population segment. And then subsection B, which is the intent, reading that it's the intent of the General Assembly to decrease the numbers of incarcerated persons subject to a life sentence and reduce the costs of incarcerating this population by offering a second look at their sentences through a judicial review by judges that permits granting relief from life sentences for those persons who are deemed worthy of a reduced sentence. So some figures, some intent. We can move on to section 2, which is the meat of the bill, unless there are any questions on section 1.
Well,
yeah. Well, first, when it was talking about the percentage exceeding the national average, I would be more curious on a per capita basis of where we stand, because I don't, I think our average in terms of how many people we have incarcerated is much lower than other states. So it sounds like to me that percentage may be higher because they're putting people in prison that have committed a very egregious crime, and that's just lower. And we're not putting people in for low level offenses as much for minor crimes. That's how I take that. So I don't think that might be misleading.
Well, I would address that with the sponsor of the bill.
Okay.
Because he is the keeper of the supporting evidence of this. So if there's other data that might be more satisfactory to the committee, I would go to Representative McGuire first, and then.
Okay. I wondered that too, Will. The one, yeah.
Well, they do.
What was it like 10 years ago before decarceration began? Yeah.
It could be the maximum sentence conviction as well. Okay. That's other.
because they have minimum max, and a lot of states may not have minimum max. They have a determinant.
Right. Yeah, and Vermont typically tries to stay away from mandatory minimums.
Yeah, and so this is then my other line of thought. On on line 9 on page 2, it says 52 people and that it's costing roughly $7 million. So it sounds like part of the intent behind this bill is that a significant portion, because if we're going based on what we spend on our healthcare costs, that's about a sixth of our healthcare costs that we're spending on about 50 people, because our contract's about $40-ish million.
But it
All
does,
healthcare related.
this figure does exclude care costs relating to common chronic health conditions.
Oh, that excludes.
Mhm.
Okay. So that means it's actually more for those 52 people. That's just, okay,
Yes,
okay. So sorry, Sal. Okay.
that's okay.
So
But,
then-
but it's only excluding those costs related to the common chronic ones. So it may be inclusive of more serious acute conditions or long-term ones.
Right. So then so actually that goes even to my point more is I'm fine. I mean, with the intent of this is great, but I definitely don't think our intent should be releasing people just because it saves the state money if they've committed a very egregious crime. And just because they're over 55, we can look at.
I think as we get into the substance of the bill, it'll illuminate sort of what the restrictions are a bit more.
Findings, they're
Yeah.
just findings. The other thing I would question is per capita cost at 134,000.
Okay.
I would question that one too, because hate to say it, we're closer to 90,000. 134 is a little excessive. But these are just findings, and it depends where the sponsor was looking
Correct.
the numbers.
So any other questions about this portion before we get into the bulk of the bill?
No.
Okay. So section 2 adds a new section to Title 13, which is what houses the criminal statutes in our state. So it adds section 7046 entitled Second Look Sentencing. It has a short title that could refer to the act as a Second Look Sentencing Act. Subsection B establishes the concept that notwithstanding any other provision of law to the contrary, an incarcerated person serving a term of imprisonment of at least 15 years who has served not less than 15 years. So you have to have a minimum of 15 years. You have to have served 15 years. May petition the sentencing court for a reduction of the term of imprisonment. So subsection C gets into the procedure. So within 90 days after the date of that person's 15th year of incarceration begins, the department provides written notice of the Second Look Sentencing Act to the incarcerated individual, the sentencing court, the prosecutor's office, and the office of the public defender. So all of those groups or people will have the information about who could be eligible. Subdivision 2 explains that a petition for a sentence reduction pursuant to this section may be filed 6 months after that 15th anniversary, if you will. So you have 3 months to notify the people and then an extra 3 months to actually file the petition if you're the individual.
And technically it's after the 14th anniversary, right? We're in the 15th year.
On the day in which the 15th year begins. So
Cool.
I'm not good with numbers. I'm a lawyer.
No, I want to try to understand it. No, we're not doing math.
Yeah, you can do the math.
Tiny problem.
But yes, after the 15th,
I had to put it on.
like the year begins.
Yeah.
Yes. No, good clarification. The petition must be filed with the sentencing court and can include affidavits, declaration, letters, records, and really anything else that's relevant to the petition. The petition must include, however, the name of the incarcerated individual, the name of the petitioner if it's different than the incarcerated person. So sometimes there's it could be the attorney, it could be an interested person, a family member, and there are procedures to kind of prove who they are, which you'll see in subdivision 1 there, a factual statement that includes the petitioner's relationship to the incarcerated person, an explanation of why the incarcerated person cannot file the petition, and how the petitioner is acting in the best interest of the incarcerated individual, any relevant docket numbers for the underlying case or cases, any offense for which the qualifying term of imprisonment was imposed, the term of imprisonment served for each docket, the date of any offense, and any qualifying sentence imposed. those specific offenses for which the petition is being requested, and a factual statement detailing how the person meets the eligibility requirements under the act. So as you'll see, it really goes through. If you're not the incarcerated person, we need to know who you are, why you're here, and what your relationship is. And then we need to have a lot of supporting information about the underlying crimes, offenses, sentences, and reason why this person should be released early. Subdivision 4 explains that a petition filed must be assigned to the judge who imposed the original sentence if they're available, because judges retire, judges cycle out, and we're dealing with long sentences. So it's not a mandated requirement. It's just, if you can do it, let's do it that way. Or if the petitioner requests a different judge, that's permitted as well. If the court determines that the facts stated in the petition aren't enough, the court can provide another opportunity to amend the petition. And the court may also issue an order denying the petition and notify the petitioner and the incarcerated person of that denial. But that denial can be considered an appealable final order. So that could be appealed to the Supreme Court. The court also must provide the prosecutor with a copy of the petition and any accompanying exhibits. So that's a change in the normal burden, where normally the filer is the person that serves those documents. Right now, this puts the burden on the court to provide those documents to the prosecutor. The incarcerated person or petitioner must not waive the right to the petition the court under the Second Look Sentencing Act, nor can the prosecutor request a right of the petition. So it's preserved no matter what is done. But notwithstanding any other provision.
I just really need some clarification on that 7A. An incarcerated person or petitioner shall not waive the right to petition the court. What does that mean?
Means that they can't give up that right. It's preserved regardless of what their wishes are.
Okay. Why are we specifically stating that?
I'm not aware of the specific reason, but I can extrapolate that perhaps there could be plea agreements that might incorporate such a waiver. And so they're saying that basically this can't be given up pursuant, like that could be one circumstance, and there might be others that I'm not aware of.
That helps. Thank you.
Yeah. So it's subsection B under 7, or subdivision B rather, that notwithstanding any other provision, an otherwise eligible incarcerated person or petitioner shall be eligible to file a petition upon the consent of the prosecutor. So just saying, if the prosecutor agrees to it, you're going to get it filed. And neither statutory mandatory minimums nor fully executed plea agreements shall preclude an incarcerated person or petitioner from seeking relief. So that kind of is a belt and suspenders approach to the previous provision that you asked about, Representative Hedrick. And then finally, in subdivision 8, the court determines the facts in the petition, establish eligibility, then you set a sentencing hearing. And then there are various time limits that are outlined based off of medical conditions or other factors about when that sentencing hearing needs to occur. So it must occur within 45 days after the petition is filed, unless there's good cause. If the incarcerated individual has one or more medical conditions leading to major limitations in activities of daily living, including but not limited to serious mental illness or an intellectual or developmental disability. It must be scheduled within 45 days if the individual has one or more medical conditions that makes them more likely to contract an illness or disease while incarcerated, leading to death, or cause the person to develop a medical condition that prevents the performance of one or more daily activities of life without assistance. Those conditions include any condition related to weakened immune system like HIV or AIDS, debilitating health conditions as a result of dementia, Alzheimer's, or other degenerative brain disorders, cardiovascular disease, chronic lung disease or asthma, diabetes, hepatitis C, seizure disorders, the need for life-sustaining care like feeding tubes or colostomy bags, disabling neurological disorders like MS or ALS, or any condition that requires or is expected to require specialty care or recurrent hospitalizations. So
All of them.
and the petition is filed by the prosecutor. So if any of those three are met, hearing is held within 45 days. I'm sorry, petition is filed by the prosecutor. So if it's being filed by the prosecutor, the presumption is that they're sort of in agreement with this, because otherwise it would be coming from the petitioner themselves. So if any of those three conditions are met, hearing within 45 days.
I don't see where it says any of those three. It says one or
Well-
more. Am I missing something way back?
Oh, sorry, then I misspoke. Yeah, so one or more. So you need at least one.
Well,
So-
everybody has at least one.
Right, but I mean, one of those, so the way that this is structured is a little unorthodox because it's just the way I could do it. But it's those medical conditions that were listed under subdivision B. Sorry, I lost my place here. And then if you have those major limitations and activities of daily living, or if the prosecutor files a petition. The hearing must be held within 90 days, unless there's good cause. If the petition does not meet the criteria that we just went through, and the incarcerated individual has served at least 25 years of their sentence, and the person is at least 60 years of age. So 90-day hearing within 90 days, if the person served 25 years and they're at least 60 years old. And then finally, subdivision C states within 180 days, so roughly 6 months after the date of the petition is filed, unless good cause, if the petition does not meet the criteria at all for those, shorter time periods. So bottom line, if they're eligible, sentencing hearing has to occur within 6 months unless you meet those other conditions that require the expedited hearing. Any questions before we move to subsection D, which is the hearing itself?
Yeah.
Troy and then Will.
I mean, I'm gonna be in support of this bill. I'm really trying to get my handle on jurisdiction right now. The only corrections intersection here is notification 3 months prior and a report, an annual report about savings. So I'm just kind of hitting the pause button to see how much of this,
It's corrections or judicial.
yeah.
Yeah, a lot of it's judiciary.
And I'm just wondering if we want to start it there.
Well, some of this is also compassionate release.
It's similar, yeah.
And we've worked on compassionate release in this committee for years.
I mean, that would be added to this version.
Well, this is a different way of approaching compassionate release. This is
Calling it compassion.
compassionate release.
Yeah.
Yeah,
It really is.
okay.
Compassionate release.
I just want to be really clear, before we really dive into everything we've been talking about so far, with the exception of the notice, has been judiciary, has been the courts.
Yeah, and I think from a jurisdictional perspective, I'll try to orient the committee as it may venture into judiciary related issues or not. But I think something important to remember is that, and you identify it, DOC has the obligation of notice, and really facilitating the provision of the records that the petitioner may want to include in the petition as well. So there's absolutely a role, and you're also dealing with someone that's housed in the facilities.
Certainly.
But you've identified it correctly, Representative Hedrick, that the bulk of this is court procedure.
Yeah.
Will and then Sean.
So we're talking, okay, so compassionate release was just mentioned, that this is essentially similar. When we're talking, so we're gonna go back to page 6, all these different conditions of people being released. This sounds to me like this is getting rid of DOC's liability over someone that has a disease or a medical issue like Alzheimer's, in my opinion. Just because I have a relative who has Alzheimer's right now that just got released from DOC, and he's causing chaos all in his community. Where's the recourse for if they get released from DOC that they'll be, is that anywhere in this bill? Because I'm not asking your opinion, but is there anywhere in this bill that essentially makes that, you you release them from DOC custody and they're somewhere that's safe for them. Because in my opinion, the way I'm reading this, we're just going to release them because we don't want to take care of them. We don't want to have liability for that. And that happens way too much. And I'd rather personally still see them in a safe setting, even if that's an incarcerated setting, than being put out on the street and having to fend for themselves. Yes, sir.
The short answer to your question is no.
Okay.
However, what you'll see too is that even if these petitioners qualify for early release, it may not be immediate release. They're just asking for a reduction of their sentence. So they could be serving 50 years in prison and then they petition after their 25th year, right? And the court views all the factors that will go through and they say, you know what, we're going to take 5 years off your sentence. You still have to serve a lot more. So that's important to remember in the context of the bill. Like, could it lead to an absolute elimination of the remaining sentence? Sure, but it may not as well. It may just shorten the sentence that they have to serve.
John?
Well, it's more of a question to you, Chair.
Uh-oh.
Well, you said you had talked about compassionate release in the past, so I guess I was just wondering if you could expound.
What
on
is
that.
it? Compassionate release, what has been in the past, that if a person has reached a particular age, sometimes it's just if they've reached a particular age, then they should be released from an incarcerated setting. That's one factor, one piece to some of the legislation we looked at. It's the number of years that possibly they have served. But once they reach a certain age, like 65, they would be eligible for compassionate release, which means they could be released. Another version of compassionate release is if you've served X number of years and you've certain age and you have some health issues and whatever, it could be serious health issues, then you could be released. We do have mechanisms to deal with those medical situations. We have on DOC's side, we have medical furlough, where they could be furloughed out. They could be furloughed out to a long-term care facility. They could be furloughed out to a nursing home. They could be furloughed out to a family member. If, that they have a debilitating disease like Alzheimer's or cancer that is treatable, but it's not going to give you much time. And the parole board also has a mechanism, medical parole. So we already have those mechanisms in place. And some folks just want to say, once you've reached a certain age and you have some illness, you're automatically released. Compassionate release. The issue around that is many times there's no place for the person to be released to. Family members, for the most part, may not want the person because they could have been the victim.
Yeah.
Or they just don't have the ability to take care of that medical care that's needed. Nursing homes quite often will not take an offender, particularly a sex offender, because it could jeopardize their funding stream. So that's why we are creating geriatric units within our correctional facilities.
Okay, thanks.
That's a
Yeah.
long version, but there are release valves right now.
And so then I guess this question would be more to you. With the geriatric facilities, do we have capacity for that in the state right now or no? Like
Within our current facilities?
Within our current facility.
The only thing is we're trying to do some of that at the Springfield facility because a lot of it is mobility issues. So we don't have elevators in our facilities. We have stairs. We don't have elevators, security issue. We don't have elevators. If there were elevators in our correctional facility, you'd have to have full-time staff in the elevator all the time. That's a security issue for that. So and the Springfield is the most adaptable one where there's a living unit that we can do. And I think you have a lift on one of those stairs to go up to the second level for that. But when we build new facilities, we will be building in geriatric units. That's the goal.
So I care.
Hmm?
I care down in Bennington, a nursing home, in which we can medically furlough folks to that facility. It's secure.
So you
nursing home.
have, okay.
Right?
So does this bill then distinguish itself from those other efforts at compassionate release because there's this additional hurdle with the prosecutor? What makes,
And the other ones didn't have the prosecutor. The other one was just internal to
Yeah.
DOC.
This is sort of an, if you will, a judicial procedure that doesn't currently exist.
let's get back to trust. Okay, yeah,
Yeah.
okay.
Just,
Yep.
yep, just because, and I don't want to put you on the spot, Isaac, but eye care is a very controversial development that's being put in Bennington. While we're on that topic, could you clarify to me, because people in Bennington, whether there's truth to it or not, think that eye care is going to allow people that are in these facilities to be out and about in the community. Is that true or not?
I can tell you, I was at the eye care facility a couple of months ago, maybe in the fall. And the individual that we had there was not going anywhere fast. Was not mobile, was in a wheelchair and was moving pretty slowly. Someone who's spent many years in Puerto Rico. And he really needed more of a medical home, retirement, medical nursing home, skilled-based facility. Environment as opposed to a correctional facility environment. I think the commissioner has said this session and past sessions that we have about 25 folks that we would medically furlough today if there was a skilled nursing bed available for them. Josh Rutherford and Pasha were here earlier, can speak to this, that we've placed many calls trying to get those folks placement. And it's very difficult to find places of acceptance. We're very thankful for Bennington, the community of Bennington, for stepping up. It's a great facility. It's a secure facility. So we have found it an incredibly valuable asset for our system.
And just to elaborate, so you said about 25, if you could potentially, do you happen to know how many people are in the eye care facility right now?
There was just one when I was there last year. They might have gone up to a couple, and they're slowly adding capacity. Yeah.
Okay.
They had
Who
about,
was staffing that? It's not DOC
no,
staff
it's a contractor. Yeah.
contractor, the DOC contracts with, or the state,
I think it's through Dale.
Dale?
Actually.
Okay. Keep going, Ben.
Okay, now we're in the actual hearing. So the way that this goes is that the petitioner or the prosecutor can request, and the court would then hold a hearing on the petition where the parties are given an opportunity to present their argument in support or against the petition. The court has discretion to permit parties to present evidence that the court deems relevant to the petition, including testimony, affidavits, short statements, documents, tangible evidence, or other evidence. That basically just puts into statute what the court would already do anyway. Then there are the orders that the court issues under subsection E. So first, after the hearing, the court must issue an order detailing its decision to either grant or deny the petition. Then in making its determination, the court considers various factors: the age of the petitioner at the time of the offense and relevant research regarding development of the youth brain, if it's relevant, the age of the petitioner at the time of the hearing and relevant research regarding the decline in criminal behavior as individuals age. That's sort of in line with that concept of assistance that has been discussed in the past. The nature of the offense, including changing societal attitudes regarding the propriety of criminalizing the offense and the appropriate sentence for the offense. I think an example of this would be, say, the evolution of cannabis laws in the state from criminalization to deregulation to now legalization. So if people were somehow serving lengthy sentences for that in the state, but I don't think they currently are for this, but just as by way of example, that would be a potentially societal change regarding a law. Then the circumstances of the offense, including the petitioner's role in its commission, whether the petitioner was essentially under coercive control of another, whether the petitioner was a victim of domestic or sexual abuse at the time of the offense, and whether the domestic or sexual abuse was related to the person's participation. So that's like human trafficking. That's one of the factors that would be considered within this. In E, the history and characteristics of the petitioner at the time of the hearing, including rehabilitation demonstrated, the petitioner's disciplinary record, their participation in any educational, therapeutic, or vocational opportunities, and then medical records and reports really to get a holistic view of their health conducted by a licensed healthcare professional. Statements and impact statements provided by any victim or family member of a victim affected by the offense. Any evidence concerning whether the petitioner's original sentence was in any way enhanced because they exercise a petitioner's right to a trial. So for context, a lot of times when prosecutors and defense attorneys negotiate a plea agreement, they'll negotiate a lesser sentence. But if they go through with trial, they may ask for, an enhanced sentence, if you will. But that is a factual point that would have to be litigated. And then any evidence that the petitioner was denied effective assistance of counsel at any stage of the original case, including the plea negotiation stage. And then finally, anything else that's deemed relevant. Two, if the court grants the petition for a reduction in sentence, so the petitioner wins a reduction in sentence, there's a restriction on filing successive motions for at least 5 years after the day the petition was granted. And so the rationale for that goes to the point that I made before, Representative Greer, about, maybe you're not getting out right away. Maybe it's just, okay, you still have 30 years remaining on your sentence, but they only agreed to a 5-year reduction off the initial sentence. So you can't go right back and say, okay, I want another bite at the apple to keep doing it. You have to wait 5 years before you do it again. And then under 3, if the court denies the petition, the incarcerated person or the petitioner can't file another petition unless another 2 years have elapsed under the denial, or after the denial. The court, in its discretion, can say that you can have a longer waiting period, but in no event can that waiting period exceed the 5 years from that I mentioned before. Under B, an incarcerated person who's denied shall only have the petition denied once for a period of at least 2 years, but not more than 5 years after the initial petition was denied. So if they refiled it, it could only be denied in that time period.
I just need a few seconds to read this one again. Incarcerated person or petitioner whose petition is denied shall only have the petition denied once. Why I can't figure this one out.
It's
Period of not less than 2 years, but not more than 5 after the initial petition was denied. So they were denied once.
mhm.
And then for a period not less than 2 years, but not more than 5. So it's between the 3rd, 4th, and 5th years.
Yes.
After the initial petition was denied.
Precisely.
But it can't be not denied again? That this is what caught me. That reads like a rubber stamp approval.
Right. Well, I think that this accounts for, and again, the language can be clarified and perhaps Representative McGuire might be able to speak a little bit more to the specific provision. But, I think that this basically says that you can't rubber stamp another denial. You could change the petition and the basis of it after 2 years, which kind of makes it new again, if you will.
Okay.
But a petition can't be denied more than once after that 2 years, but within 5.
Did they tell us?
And you can clarify it too.
Okay.
Yeah.
But I'm with you that it takes a couple times to read it.
Yeah. I'm just gonna press question.
And then
Before we move on, because I've been meaning to ask this for a minute, going back to page 8,
Mhm.
1A, when we're saying the age of the petitioner at the time of the offense and relevant research project development youth brain, do we have a definition for what that age would be considered a youth brain? Because I understand.
There's no definition, contained in the bill, but, through testimony on other bills and other committees, my knowledge of it's typically, the full development of the brain doesn't occur until you're 25 years old, but there's questions surrounding that research. So this would be something that would be determined by evidence, what's presented to the judge, and the judge would then consider that within the judge's decision.
Yeah, I just thought it was left vague because research continues,
Yeah.
Right. I personally, for what we're talking about here, I think there should be something more concrete. Maybe we get down there at the end of the line, but I don't like leaving it that vague and that open.
So
We
this
can go
is
back
just
and
the
change
first, this is the first walkthrough to determine if you even want to work on the bill.
Mhm.
So we're not gonna get, it's not really a time to get in, well, I want this, I want that.
Okay,
It's to understand what the bill is really saying, and then determine as a committee whether we want to take further testimony and work on it.
Okay, so we were on page 10, I believe. So victims' rights under subsection F. So upon the filing and notice of any petition, the prosecutor also notifies the victim or the victim's family and then provides copies of the petition and any accompanying documents. The prosecutor shall, if practicable, consult with victims of the person convicted of homicide prior to responding to any petition filed or consenting to the petition of an otherwise eligible petitioner. 3, the victim of the victim's family, or the victim or the victim's family, that's a typo, shall have the right to present at any hearing held pursuant to this section and shall be permitted to provide written or oral statements concerning the impact of the offense and any position as to whether the petitioner should be granted. So basically, the victim or their family gets to file something outlining their position. And then 4, any order granting a petition that modifies the petitioner's sentence shall not affect the underlying order of restitution. So basically, if part of the initial sentencing was you owe X amount of dollars for the crime that you committed to the family, the reduction in sentence wouldn't affect that requirement.
Troy?
I had flagged victim notification on page 3,
Mm,
section 1, A, B, C, D. Is there a reason why we don't put it there?
It was just the order of how it was listed.
Okay.
There was no intent one way or the other behind that.
Kevin?
If a victim does not have the resources to obtain their own or bring on their own attorney, do we supply attorney for them in this issue?
No, but there's no requirement for them to necessarily have an attorney in this. They wouldn't necessarily need one. They could just submit a petition once the prosecutor notifies them. Because they're not a party to the case.
Oh,
This just allows for their position essentially to be filed with the court for it to be considered. But they're not a party to the case. It's kind of a special permission that the victim or the victim's family is given in the statute.
okay.
Subsection G is habeas corpus and other remedies. So the section essentially is saying this is not abridge or modify any existing remedy that's already available to incarcerated folks, including a habeas corpus claim, statutory or post-conviction relief, or any other legal framework. So just stating their rights are maintained. This doesn't affect it or take anything away. It's just, if anything, supplemental. And then under subdivision 2, a petition filed pursuant to this section shall not impact or be impacted by any habeas corpus petition or other relief that is being sought by the petitioner, and does not preclude those other forms of relief from being granted. So again, this is just a supplemental avenue, if you will, for the incarcerated person to get a reduction in sentence that doesn't affect anything else.
Questions? Now, remember, we're just getting a broad walkthrough. We haven't decided if we're gonna work on this bill or not.
Yep.
Yeah,
is there similar language that we would see well, first of all, in statute currently that does second look, or is this completely this
This is a new procedure that's being established. I mean,
Yeah.
as Representative Emmons said before, there are other sort of more internal procedures to do it. And then you can file for post-conviction relief if potentially new evidence comes to light that exonerates you. Or if you had ineffective assistance of counsel, like there are legal procedures in court that you can already pursue, but this concept itself would be new in statute.
Okay, and then second part of that question, just on a more comparative, broader basis, are there examples of this having taken place in other states or jurisdictions that we could take a look at and see?
I am aware of it being enacted. I believe New York has it. But I couldn't give you the details of
Okay.
that right now.
It's okay, thank you. Still take a look.
Moving on to section 3, at my peril. So this creates a report and recommendations, based on the Department of Corrections and an obligation imposed on them that every year on or before July 1st, DOC shall submit a written report to the Justice Oversight Committee detailing any savings to the department as a result of this act, with recommendation to fund any specific victim support services, correctional facility, and community-based programs to address recidivism through educational opportunities, therapeutic intervention, familial and social supports, and restorative justice approaches. In addition to those, reentry and community reintegration initiatives and personnel within the Attorney General's office, the Office of the Defender General, the Department of State's Attorneys and Sheriffs to represent and support the parties involved in these proceedings. So essentially what this is saying, DOC, take a look at your savings and let's see if we can reinvest them either in the community or into the staffing needs to support these procedures. Section 4 is the applicability, that notwithstanding Title I, VSA 214, Section 2 of this act shall apply to sentences imposed prior to the effective date of this act. That is important to clarify that this is a forward-looking change. So people that may have met eligibility requirements before this goes into effect, you wouldn't just be seeing a flood of petitions years after the fact. And so it's only forward-looking after its implementation date.
So it's only for those folks sentenced after the effective date,
Mhm.
not
Yeah,
going back to the folks who are currently sentenced.
correct. So it's only sentences that are imposed after the date. So essentially it goes into effect on July 1st of this year, right? Let's say someone has a sentencing hearing on July 2nd and they're sentenced, they would be eligible. But if they had a sentencing hearing prior to the effective date, this wouldn't apply to them.
Well, I guess I just have a clarifying question with that. Would someone that met eligibility requirement on that 15th year, let's just say they're serving a 50-year sentence and they hit that 15th mark 20 years ago and they're on year 35 of their sentence, they would be eligible for this? No.
No, because they
No, because the sentence has to be handed down after the effective date.
So
It's the underlying sentence,
going forward, you're not going to impact anyone who's currently
correct?
sentenced.
So maybe I'm not understanding this fully, but so we wouldn't really see any second looking
It would
for
be
like
15 years.
15
years. It would
So
be a
we're
long
talking
time.
about like, this would not even get off the ground until 2040, basically. Yeah,
More or
okay.
less.
Some of us will be dead.
But
Sounds awfully close to that. I'd like to think.
So,
But you never know.
We're not starting any market for pool.
Brian?
Ben, I don't know if you know anything about sort of the creation of the bill or who they talked to, but I'm curious whether I see the portion in here that deals with victims but were victims or victim advocates involved in any?
I don't know.
You know,
No, I think it's a better question.
then we'll talk about it, right?
I do know the sponsor did work with an external organization. I cannot recall who, but I would defer to him.
Okay.
Well, we've been trying to get the sponsor in, but due to circumstances. Troy?
I do know we have an advocate in the room, Dick Wickenberg, who has connections to advocacy groups that are going to be in the building next week. If we want to maybe hear a little bit more.
It's up to the committee if you want to hear some more on this.
I'm always open to hear.
I want to hear.
Yeah, I'd be interested.
Okay, well, maybe connect with Phil.
Yep.
Just kind of set up some time.
Great.
Not a lot of time, but time.
Yep.
So let's move on to pretrial supervision. I have a meeting at 11:30 I have to get to. So
You want me just to go through the statute itself, or do you want me to go back through the presentation that we reviewed in January?
and that, what I want is for the committee to understand what we have in place now for pretrial supervision out in the community, because this has come up committee a few times about supervising folks in the community prior to them being sentenced.
Right.
So whichever one,
But probably more digestible is the presentation rather than the statute itself, but
that's
the,
fine.
the statute and the presentation are both posted on the website.
But you can bring that up, right? Yeah, why don't you do that? I know you presented it at the beginning of the session. Everyone was brand new to the world of corrections. Now you got a little bit under your belt. You might be able to understand this a little bit better. And then it can also tie in with a lot of other corrections issues, and supervision issues out there.
So as you can see, this was dated from a couple months ago. I apologize for not updating the date of presentation. So the pretrial supervision program governed by 13 VSA 7555, which went into effect last year, or rather the beginning of this year, was passed last year. It is basically the overview of the pretrial supervision program. This is what permits individuals to have some level of supervision before they go through a trial. It's a DOC responsibility. It's imposed by the courts, and it's imposed as a condition of release under 7554. Specific statutes are cited, but 7554 is the conditions of release statute. The pretrial supervision is worked into that statute as a condition that can be imposed. There are certain eligibility requirements. Like I said, it's court ordered, it's DOC administered, and then there's also a compliance and review procedure that's incorporated into it.
So would this happen when a person is arraigned? Or does this happen when they are sentenced or in between?
It could happen at arraignment or prior to sentencing, but it wouldn't happen at sentencing.
And it's done by the court.
Yep.
So prior to us putting pretrial supervision, the program in place, a person could be released, they were arraigned, they were released by the court, and the court set some conditions upon that release.
Mhm.
And some of those conditions could be, you may have had a curfew, don't go near someone's property, don't go to a bar. It could be a list of conditions. But there was no supervision of that person out when they were out there.
And that's
The only supervision was if law enforcement, police department found them doing another criminal
And that's
act.
how it currently works right now. There is, prior to this statute, the only form of supervision that you could really construe in such a way is, as you just stated, Representative Emmons, and then also the home detention and like electronic monitoring, but that's separate and apart from
Totally
this.
separate.
So this is really the first iteration of any pretrial supervision that's mandated by the court and administered by the department.
So one of those conditions would be there'd be some supervision
Mhm.
by the PMP office of DOC.
And while this could, I should qualify that like this could start at arraignment, but really the way the process is designed, it probably wouldn't be imposed at that point because there's a little bit of sort of a investigative process, if you will, that DOC has to do prior to the court imposing it. And I'll get into that.
So are there any questions on this high level right now?
I've got to ask again what arraignment is.
Arraignment is like the first time that you have to respond to your charges. So, let's say, you committed a crime, Representative Winters, not saying that.
We're held at a correctional facility over the weekend.
Right. You were given a you were given a citation to appear at a certain date and time. That is your arraignment. So that's when, let's say, if you had your own attorney, they'd show up with you, you'd enter a plea. The defense attorney is there, and then that's where your initial conditions would be imposed, if any.
Got it.
Yeah.
So at that arraignment, you can be sent to jail without bail or with a high bail, or you could be released back to the community with bail, then you can make bail or without bail.
Or you could be released on your own recognizance with no
No
conditions whatsoever.
First time you end up before the judge.
Yep. First impression.
Person,
Yeah.
lucid.
Yeah. Right.
Yep.
So moving on to the next slide, like I said, there are governing statutes. 13 VSA 7554 governs pretrial release, those conditions that can be imposed. The court assesses various factors. Is that large enough for everybody to see? Do you want me to make it No, that's fine. Okay. Risk of flight, seriousness of the offense, the number of offenses, current conditions already imposed, probation, furlough, various factors that the court considers in imposing which conditions are appropriate. Again, they have to be the least restrictive ones to be effective, but the court determines based on a variety of factors what those are. Pretrial supervision is one of the newer conditions that was added last year. And again, under 7555, the purpose of the program is to assist those who are eligible through the use of evidence-based strategies to improve pretrial compliance with conditions, to coordinate and support the provision of pretrial services when appropriate. So if you need to be screened for substance use disorders or whatever, it's supposed to help connect you with that, to help ensure attendance at court appearances, and to decrease the potential to recidivate while awaiting trial. So that's the overall purpose of the program itself. So who's eligible? Someone that's accused of violating conditions of release pursuant to 13 VSA 7559. What that statute is its own crime. So if you have been alleged to have violated conditions of release and a prosecutor has filed a charge under 7559 for that, you are presumed to be eligible for this pretrial release, or if you have at least 5 dockets pending against you. So it kind of funnels certain individuals. So not everybody is eligible to this, because there was a lot of discussion during the passage of this bill about overburdening the courts, overburdening prosecutors, the department. And so this was a way to sort of funnel certain folks that might have some evidence of problematic behavior or worrisome to kind of reduce the number or the burden on the system, if you will. So you got to have 5 cases against you at least, or a charge of violating your conditions against you to be eligible.
So you have to earn it. You kind of have to earn it in a way,
In a negative way.
in a negative way, but you got to earn it in a negative way. So it's not everyone that shows up for their first time that they've committed a crime. They wouldn't be eligible for this, but if it was the first time they committed a crime, they were released with conditions. And then a month later, they violated a condition, one of those conditions of release, then they would be eligible.
I'm still lost on the logic of requiring someone to have been accused of doing a certain number of bad things and then saying, okay, now you can go back out.
The testimony was just about the burden on the system.
Burden on the system of-
Judicial system.
Yeah.
and DOC, because they're the ones supervising.
And Senator Sears did pose it as a way to potentially move people from an incarcerated setting. So we're being held maybe for lack of bail, or if we're being held without bail or something, and trying to monitor them more in the community. And so, and I'm talking to Judge Tebow up in Orleans County, I think that's his hope. We've yet to see the volume of cases to really see that play out.
I mean, this is a big shift in terms of supervision in the community while someone is waiting a court date for sentencing, because there's no supervision now.
Mm.
This is an increase in cost to DOC by about 1.3 million, maybe more. And it's also what's going to happen is they're going to be caught violating conditions now that they wouldn't have been before because they're being supervised. So it's going to put more pressure on the courts. They're going to be coming into court with more dockets.
And part of the initial request under the bill was an increase in staffing levels to the department to help shoulder it, which didn't happen.
Half of it happened.
Yeah.
600,000.
Right. But initially, I think they requested, 12 new staff members and 2 support staff, and then it was reduced, to 6 and 1? Or no, 2
We
and
got
1.
five staff, but we only got funding to really do about 2. So
So there you go.
And the 5 pending court dockets, that can be any court docket. That doesn't have to be a five times of the same offense.
Right. It could be. Yeah.
Either or.
Yes, exactly. Like it could be someone that over the weekend, let's say, went on a crime spree and broke into 5 different people's houses. There were 5 complaints and 5 dockets that were created as a result. That's a possibility.
That's a possibility.
Mhm. Any other questions on this portion? So what's the procedure? So at arraignment or a subsequent hearing, so any time before trial, A party or the court may move that someone who's eligible can be reviewed to determine whether placement in this program is appropriate. The review is scheduled upon receipt of a DOC report containing recommendations on the defendant's supervision level. Once that's done, the court reviews the report, schedules a hearing to determine if the placement is will reasonably ensure the defendant's appearance in court, will reasonably mitigate the risk of flight, or reasonably ensure protection of the public. To make that determination, the court considers the nature of the violation of conditions of release under that 7559, nature and circumstances of the underlying offense, their criminal history, mental health needs, risk of flight, any risk or undue burden that they pose to third parties or to the public in general that may result from the placement, and then any other factors that are deemed relevant by the court. So that's how the court goes through the process of determining placement. So once you're eligible, then the placement determination occurs. And that's dependent on the report that's filed by DOC with the court. The court then reviews it, schedules the hearing, and factors in these different considerations in making the decision on the placement.
There are different levels of supervision.
There are.
It's like you know.
So yes, there are essentially different levels. The first one can be through the DOC's telephonic monitoring system. So these are essentially automated phone calls reminding people of court dates and when to show up. So that's probably the least intrusive supervision level. It's really just kind of automated reminders. Then you can have telephonic meetings with a pretrial supervision officer. So someone that physically gets on the phone and talks to you to check in to see how you're doing. You can have an in-person meeting with the officer. You can have electronic monitoring, so ankle bracelets, or any other means of contact that's deemed appropriate. So it could be, let's say, meeting over Zoom, or any combination of these different supervision levels as determined appropriate by the department in its report.
Or this one with the binoculars following you.
Or this lady.
That's fine.
And who sets all of those levels of supervision?
The court. So it's done through the recommendations submitted through the DOC's report, reviewed by the judge, and the judge would then order it.
Any questions?
Isaac.
Isaac, I'm sorry, I got to respect or something.
Important, yeah, important piece of context too is, I remember in the original draft of the bill, we actually had the courts were the ones assigning the electronic monitoring. I think for speaking to the department, an important shift we made was allowing the department to assign the supervision level, the person in the program. That's what our probation parole staff do. As we talked about the other day, with the validated screening instruments, both within facilities and in the field. And so they're able to kind of calibrate rather than the court just assigning a full ankle bracelet. I think the department can take the time to really work through what might be most appropriate. We've also secured a text message notification system using the funding that we got for pretrial supervision. So everyone who's on pretrial supervision, and actually everyone who's on any form of community supervision, probation or parole, will get now an automated text reminding them of meetings with their probation officer, as well as important court dates to try to draw down the failure to appear that you see sometimes with this population.
Okay. Any other questions on the supervision levels? Okay, moving away from the lady with the binoculars. So compliance and review. So what happened? How is it determined that someone is complying with these conditions, and how can that be reviewed? So essentially, pretrial supervision officers must notify the prosecutor and use reasonable efforts to notify the defendant of any violation of court-imposed program conditions. So if it's a court-imposed condition that's violated, the prosecutor must notify the pretrial supervision officer must notify the prosecutor of that. Pretrial supervision officers have the discretion, may notify the prosecutor and use reasonable efforts to notify the defendant of any violations imposed by the department. So administrative conditions. So like, you didn't charge your ankle bracelet. That's a duty that someone who has one must abide by. But that's an administrative condition that There can be a lot of reasons why that doesn't happen. And so as a result of that, the pretrial supervisor has discretion to make that report. The parties or the court may move for the court to review the supervision conditions. And then the prosecutor may file the pretrial supervision officer's sworn affidavit with the court to issue an arrest warrant for a defendant who fails to report to the pretrial supervision officer, commits multiple violations of supervision requirements, or has absconded. So that's an extra requirement on the pretrial supervision officer to make that sworn statement before the court justifying an arrest warrant. So any questions about the review and compliance? And the way that this would work too is that so anybody can move the court to review this. So for instance, if there are multiple violations and something's not working, the prosecutor can ask for a review. Or if the defendant is being extremely compliant and they have maybe a more burdensome supervision level and they've been compliant, maybe that's a demonstration of compliance that warrants
Reduction.
a lower supervision level. So there's room to go either way.
Is this making sense to folks? Sean,
Just have a quick question. So, you know, it sounds good, but does it, it seems like it's a lot of work.
Yeah.
So I just big picture, it just seems like, so who's on top of all this?
well,
All the different levels?
we haven't rolled this out fully in the
Oh,
state yet.
okay.
Right.
Okay.
Yeah.
All right, then
Currently in
Two
pilot.
counties.
There's
Yeah.
only two
Really
counties
just
because
one, yeah, well.
they didn't get the full funding. We didn't get the
Gotcha.
full funding.
Yeah, since they didn't get the full funding for the full staff, and even the staff that they actually requested for only got a portion of that to do it. This had only been stood up in Orleans, and I think Essex was the other one, but it's really only operating in Orleans.
And now you said that, Ben, you did say that earlier in the year, but I'm just,
It's a lot that happens.
yeah, thank you.
No problem.
You'll get it. You'll get it.
Okay.
But to your point, Representative, I think, you know, we are working with the state governments. They're very interested in this because I think Vermont is the first state to roll out pretrial supervision. Statewide, it's usually done by the courts, where it's usually done at the county level. But for the state DOC to do, I think we're unique in the nation for doing it, operating it. And so something that CSG, David Demora, who I know testified to this meeting, but the report is due out in June or July. I'm not sure if you want to have him here, and then maybe also join Justice over some of the report comes out. But he had some thoughts on this slide in particular around the, you know, different legislative pathways for notifications and compliance. I think there might be some opportunity to tinker with the statute next session.
Let's see.
To
Work it through.
streamline some of this is something we found, stuff about violations. Moving through the prosecutor might not be the most expeditious pathway, you know.
Seems
you better to
burdensome.
file with the court
Yeah.
directly. So anyway, we can get into some of that with David Demora in the coming weeks.
Thank you.
Troy, did you have your hand up? No.
And then finally, policies, procedures, and program support. So this deadline's already come and gone. DOC must establish written policies and procedures for the program, not only for the department to use, and any contractors or grantees that they engage with, but also to assist the courts in understanding how the program works as well. They also must develop their own policies and procedures for the supervision levels, what determines who gets what, based on evidence-based criteria for the supervision level and the means of contact that's appropriate for each level. And then DOC has the authorization to engage with any public entity that meets its criteria to help in operating the program itself. And the program is contingent on funding. So essentially, if the program's not operating, it's not an option for the courts to impose. So it must be funded to go live.
For the funding process that occurred, there was only last year to really roll this out statewide, it was around 1.2 million for DOC. And in the budgeting arena of appropriations, it happened more in the Senate because the budget was over there. This was the Senate bill here, so we worked on it here in this committee along with Judiciary Committee after crossover. This was done last year about this time in the beginning of May. In the meantime, the state budget had already passed the House. It was over in Senate Appropriations Committee. So Senate Appropriations Committee found 600,000 basically for this. So that's why it got rolled out in only two counties for that, to see how it starts working for that. And the legislature was involved with DOC to give approval as to which counties those would go out in. So that.
So we have a year's worth of experience that we can.
By next session.
Because this only went live in January.
January.
And really only in that one county.
Yeah, it's operating out of Newport Probation Parole, which is also covering Essex. And we're hoping to, I think we just hired someone or are hiring someone for St. Johnsbury. So we're kind of, as we go, we're building it. But we do have our policies and procedures done. Those are good.
I mean, how's it going?
Well, it depends how the court operates it and sends people. It's up to the courts. It's not up to DOC.
I think that will be a great opportunity to hear from CSG as a third party evaluator. And they actually went and talked to some of the folks who were on pretrial supervision up in Newport. They talked to our staff, they talked to state's attorneys, they talked to Judge Tebow. So they have a lot to share.
How many numbers
That's great.
of folks do you
It's
know?
pretty small, like a handful.
Yeah,
of
for
us.
like
We've gone
5,
through it.
6.
Yeah, that's it. But they kind of rotate, they're not on it for too long.
And from my understanding, Judge Tebow is really the only judge that's been handling this so far. So he's probably a good resource from a boots on the ground perspective.
But to oversimplify, if we don't have this in place, we're relying on the potential offender to get to court.
Yeah, that's how it's always been done.
Right.
Yeah.
So this
Until this
is
program.
really to help the potential offender be compliant.
Mhm.
So we ought to have some numbers as to of the people that they've been working with. It's
Yeah, but it's only really been 3 months in
Since January.
operation.
I
Yeah,
understand,
yeah.
but
Yeah, and I think, you think about the population this is really designed to serve. I know Senator Sears talked about kind of a catch and release. So people on Church Street, the kind of frequent flyer folks that you hear about in the news. And some of those folks can be, they have a lot going on in their lives, a lot of substance use. And so I think that's something that CSG will recommend, is thinking about what other kind of wraparound services can we offer these folks so they can even make it to court, so they can deal with some of the underlying issues that are driving the criminal behavior.
And
That's transportation.
And that's why when you read the program itself in subsection A of the statute, it talks about, getting those people in contact with the services that are needed, those pretrial services to assist them. So that's one of the goals in addition to compliance and recidivism reduction.
And the ultimate goal is for the public to be safer.
Yep.
That was the real angle for that.
when it takes 5
Dockets.
dockets
It's for some,
before the public
Yeah, but-
is safer, right?
well, that, or they have one crime that they've committed, they've been out on conditions and they violate a condition of that release. That would trigger it too.
I think this program, from a policy perspective,
You don't
There's
need
multiple.
5.
Oh, I thought it's.
It's or. It's the word or.
Or.
5 or being charged with that
Gotcha.
crime of violating conditions.
Got it.
Yeah, but the words are and or have very different meanings.
No, I'm with you on that. I just, didn't.
It's
Pick it
one
up.
or the other. Could be both, but usually if it's a violation, if it's a violation of a previous condition, they could have one crime.
Right.
There was conditions of release that were set. They weren't being supervised. They violated a condition that was set. Now they could qualify for pretrial supervision.
Yep.
That may be also another area that CSG has recommendations on the eligibility criteria. 'Cause if I remember correctly, you sent it to share maybe a year or two ago, when we were kind of tinkering with this, it was a bit of a guess, I think was the actual language of the
Just didn't-
committee. It was more of an art than a science, kind of designing the pipeline for the
Don't steal all their thunder.
program.
Any other questions?
Does this help?
Thanks.
Is that all?
Yeah.
Yeah,
Yes.
super helpful.
If you have more time to digest it, feel free to shoot me an email.
Okay.
Scary. I don't even remember the first time. That's how.
I knew people didn't.
He gave us a
Completely overwhelmed by that.
black and white from now. Yeah.
You gotta pay attention to the language, folks.
Yeah, of course.
No, I knew, when you're first new, everything is new, so. you get it
Well, when we first went through it, it had only been in effect for like 2 weeks.
free.
Okay.
So
So, thank you, Ben. You know, if you want to discuss
Pretty good.
what you want to do for, we had John on 2 bills. So it was commissary, and what was the other one? It was just, oh, security. We want to do more work on the commissary and the security. If you folks, I have a meeting I have to get to, running a little late.
So.
If you just want to talk about that second look sentencing, if you
Yep.
want to take further testimony or not, it's up to you folks. And then you're free.
Okay.
Did everyone get this, or was I just given it?
Just you.
You're
Everybody?
Well, but what is 2023? We're in 2025.
I think, yeah, I can check on the data.
So
for
once
that.
you
I
know
think it's supposed to
about it,
refresh.
Okay.
Yep. So guys, let's have a quick discussion then on what everybody or anybody would like to do on the 379. Do thoughts, Troy first?
Second, right?
Yeah. Second. look.
Yeah, I'm a big fan of this. I do want to hear from the advocates, that, and I think Phil and Mickenberg started finding some time for that. Given that, once we do that, more big picture stuff from the advocacy, around this bill, I might want to consider handing it off to judiciary, given a lot of this is in their purview. I would hate to spend a lot of time and energy on it if, plus one of the sponsors is over there. I'd like them to get it's gonna go there anyway.
Mhm.
And I think more of this bill is with judiciary than it is with us.
You want to hear from some advocates. They're already.
Yeah, we already kind of got that. You got Mickenberg.
I'm gonna make it.
He's gonna email me and next Wednesday or Thursday is when he thinks I'll
Okay.
be available.
Then let's do the handoff.
Yeah. Any other thoughts?
Same page.
Yeah, I'd be okay with that, but obviously it's gonna fly next door.
Yeah.
This is,
That's a general gist of like, we should hear from advocates, get some ground based knowledge and then ship it next door to,
Yeah, I would hate to do a bunch of work on it and for them to say we're not doing anything.
there's no wheel spinning. All right, so that was easy. The old Staples button concludes our morning meeting, and Phil, if you could just take us offline, thanks.